She didn't knock. She didn't pause. She didn't even hesitate. She pushed the cabin door open like she already owned the space inside. Clipboard lifted like a badge she believed carried legal weight. She entered the room with the kind of confidence that only exists when a person has never truly been challenged. She came expecting compliance. She walked into jurisdiction she did not control. The door clicked shut behind her, not by force but by simple momentum, yet the sound rang like a gavel. It was the moment she crossed the line from authority into overreach. 2 more steps, polished shoes tapping against hardwood, before she noticed the second woman at the table. The Attorney General didn't stand. She didn't even shift in her chair. She simply closed the notebook in front of her, calm and deliberate, as though she had been waiting, not for the intruder specifically, but for this precise infraction to become undeniable. The HOA inspector's face registered the first flicker of doubt. Too late. The homeowner remained silent at first, watching her the same way one might watch someone walk across a field already fenced by law, a boundary invisible until violated. He didn't rush. He didn't defend himself. He didn't posture. When you are already protected by the highest legal seat in the room, you don't need volume. You only need patience. The HOA woman straightened her spine, trying to salvage poise. "I'm here to conduct an enforcement inspection on behalf of the Lakeside Residential Association," she announced, projecting the same tone she had used on dozens of homeowners, a tone trained not to question, only to command. "This cabin has been reported as non-compliant. There are outstanding access violations and you've failed to respond to written notices." She still didn't realize her footing had already disappeared. The Attorney General let the silence hang for just long enough to remind everyone which voice actually mattered here. Then she spoke, calm as measured ink. "Your authority ends at the property line." The HOA rep turned toward her as if finally seeing her in full. "This is governed by association bylaws," she said automatically, the script she always used, the script that usually worked. "Entry is permitted during review of unresolved violations." "Permitted by whom?" the Attorney General asked, tone mild, but the question was a legal trapdoor. The inspector hesitated. Not long, just a half second, but enough. That microscopic pause said everything. Her power existed only when unchallenged. "I'm acting on behalf of the board," she said. "And I'm acting on behalf of the state," came the reply, unshaken, "which supersedes your board by approximately every layer of government that exists." The inspector blinked, recalibrating. She looked back to the cabin's owner as if expecting him to be the easier target. But he didn't move, didn't justify himself, didn't explain, because explanations are what people give when they owe compliance. This time, he owed nothing. Before she could try another line, the Attorney General leaned forward slightly, not aggressive, simply establishing jurisdiction with presence alone. "You entered a private structure without warrant, consent, or legal mandate," she said. "You are not here in an administrative capacity. You are trespassing," the confidence cracked. Not shattered yet, but fractured. She looked toward the doorway as if the threshold might still grant her an escape route from what she had just walked into. But retreat would not undo the entry, and the witnesses, now including 2 off-duty deputies sitting in quiet observation, had already seen enough. This wasn't just an intrusion, it was a record. The inspector opened her mouth, excuse ready, but the Attorney General cut across her gently, like a surgeon making the first clean incision before the damage could spread further. "HOA bylaws do not outrank state property law," she said. "You don't get to enforce policies inside a dwelling. You don't have search authority. You don't have inspection authority. And you do not have entry authority." For the first time, the HOA woman's confidence wasn't just fading, it was abandoning her, like a battery draining under a light she couldn't turn off. She swallowed, gripping the clipboard tighter, the last physical symbol of control she had left. The homeowner finally spoke, voice even, steady, not defensive. "Just factual. You've come onto my property 3 times already this month. Every time you claimed you were entitled to access because this cabin falls under common inspection jurisdiction. I told you then, and I'll tell you now. This is not common property. This is privately deeded land with independent title predating your HOA by 15 years. Her jaw tightened. The board, the Attorney General interrupted softly, has no authority over map overlays they did not originally include in their charter. The clipboard sagged. Just a little. And yet, the Attorney General continued, you chose to escalate. You chose to enter without consent. And you chose, she tapped the sealed folder on the table, to do it after receiving a written cease and desist notice from my office. This time, the shock was real, not surface level, but the kind that reaches the body before the mind can disguise it. She hadn't overstepped by mistake. She had overstepped after warning. The homeowner leaned back in his chair slowly. You kept insisting this property falls under your governance because you assumed homeowners don't know the boundary lines better than the HOA does. The Attorney General's voice lowered, final and irrefutable. He does. And so do we. The inspector's shoulders squared in one last attempt at posture, but posture without authority is just theater. Her eyes darted to the exit again, now not looking for preservation of control, but for the fastest route out before the consequences caught up. But she wasn't leaving yet, not until this violation was fully established, not until she understood that intimidation works only until someone brings a bigger jurisdiction to the table. The Attorney General rested both hands on the notebook and spoke, with the clarity of law written in ink, rather, than HOA letterhead. You walked in here assuming you were the highest authority present, she said. You walked in like this was your terrain, but you are standing in a space governed by deeded property law, not association preference. You believed the board rights policy, the state rights law, and today you learned the difference. The inspector stared. Not aggressive now, just stunned, realizing the hierarchy she relied on had collapsed underneath her. She had come in thinking she was the one conducting enforcement. In reality, she had just become the case study, and the moment she finally understood that was the moment she stopped speaking. The HOA inspector didn't leave right away. She stood frozen just long enough for the weight of her mistake to settle into the room. Power doesn't disappear loudly. It drains silently, and everyone present could feel the shift. The Attorney General didn't tell her to sit. She didn't tell her to stay either. She simply turned a page in her notebook, as if preparing to move forward with the next stage of a process the inspector was no longer controlling. That small gesture alone said everything. This wasn't over for her just because she wanted it to be. The homeowner rose from his chair for the first time, not rushed, not angry, simply grounded in the certainty of someone who no longer had to defend his land, only witnessed the consequences unfolding from its protection. He stepped to the side, giving the inspector a clear path to the door, a silent courtesy she had never once offered him. But she didn't walk through it, because leaving meant confronting what waited outside, her board, her report, and the fact that she had no legal foothold to stand on anymore. Inside, she had just lost authority. Outside, she would have to explain why. She looked back toward the Attorney General with the faint, flickering hope that maybe this was a warning, not an action. But the quiet professionalism in the AG's expression wasn't warning. It was documentation. You said there were outstanding violations, the Attorney General said, voice level. State jurisdiction now requires you to identify them with legal specificity. Not HOA phrasing, not board interpretation. Statutory basis only, the inspector blinked. Statutory? Yes, the AG answered. The moment you escalated this to enforcement entry, you shifted it from policy to law. So if you are alleging a violation, cite the statute it falls under. The silence that followed wasn't simple hesitation. It was collapse. She had no statute. She had only bylaws, and bylaws don't hold inside a private structure without consent. Her grip on the clipboard loosened. This wasn't an argument she could bluff her way out of anymore. This was procedure, and procedure doesn't bend for confidence. You can't cite it, the homeowner said quietly, because it doesn't exist. Her mouth opened, closed again. The AG continued, still calm. This is why state law draws a hard line at the threshold of a dwelling. HOAs govern community maintenance. They do not govern search authority. Not through officers, not through committees, not through entry attempt. The inspector's eyes flickered toward the board files tucked under the Attorney General's folder. She recognized the seal now. And that meant she also recognized what kind of report she had just become part of. Finally, she stepped backward, not by choice, but by inevitability. The Attorney General wasn't finished. "Before you go," she said, "you need to understand the scope of what you triggered here. This is no longer a homeowner dispute. This is a jurisdictional breach that activates oversight review. Your board will be contacted. Your entry log will be subpoenaed, and every prior unauthorized attempt will now be part of the formal record." The inspector's throat tightened. "This isn't personal," the AG added. "It's procedural. You pushed your authority beyond its border. The state now steps in to correct that border." The inspector took another step back, and this time the threshold was behind her. She realized she was already halfway through the doorway, halfway out, halfway stripped of the position she arrived with. She inhaled like someone preparing to defend themselves one last time. Then she looked at the wrong person, the homeowner, instead of the one who could actually spare her, and she saw it in his expression immediately. He wasn't the target anymore. He was the witness, and witnesses don't bargain. She left without another word. The door closed behind her, not slammed, not dragged, simply shut. And in that quiet closure, the dynamic inverted completely. The intruder had retreated, and the homeowner's rights now stood on record. The Attorney General waited until the latch was fully seated before speaking again. "That will not be the last move she makes," she said. "But it will be the last move she makes unchecked." The homeowner nodded once. "The board won't like losing control." "They didn't lose control," the AG replied. "They never had it to begin with. They only had fear, and fear stops working the day someone stops believing it." Outside, the HOA inspector reached for her phone with the urgency of someone who knows she must report first or lose her version of the story entirely. She moved fast, but the state moved faster, because the moment she crossed back onto public boundary, a deputy stepped forward and asked for her badge number, name, and association credentials for the incident file. She hid the panic well, but not well enough. Fear doesn't shout. Fear tightens shoulders. She wasn't walking away from this. She was walking into the next part of it. Inside, the Attorney General turned back toward the homeowner. "Now," she said, "we begin documenting the retaliation they're going to attempt next, because HOA power doesn't stop when denied. Entry, it scrambles for another doorway. And part 2 wasn't about what they had already tried. It was about what they would try next. This time, the state would already be waiting." The HOA board did not take long to react. Within 24 hours, their confidence reassembled itself the same way it always had, privately, behind closed doors, where consequence still felt like a myth. They called an emergency meeting not to correct the violation, but to reclaim control. Retaliation wasn't a risk, it was a certainty. Power doesn't surrender gracefully. It searches for a back door. They didn't talk about the boundary law. They didn't talk about jurisdiction. They didn't even talk about the Attorney General's presence inside the cabin. They talked about optics, reputation, image, because HOA power is built on the illusion of authority. Once people stop believing in the illusion, it collapses. The inspector sat at the table during the meeting, not defiant, but shaken in a way she tried to hide beneath reports and procedure binders. She hadn't told them everything, not yet. She underestimated how much the board needed the perception of invincibility more than the reality of it. The board president leaned back in his chair, fingers steepled. "He embarrassed this association," he said. "We don't let that stand. There it was, retaliation disguised as policy review. They didn't intend to fix their mistake. They intended to bury it. Their solution was predictable: escalate administratively. If they couldn't enter the cabin, they would pressure from a distance. Fines, suspension of privileges, revocation of lake access, bureaucracy as a weapon. That night, they drafted a formal enforcement notice accusing the homeowner of obstruction, a word that sounded legal but carried no statutory weight. They were hoping his silence meant vulnerability. They were hoping the Attorney General's involvement was temporary. They were hoping wrong. The notice was delivered the next morning, neatly folded, stamped, certified, everything in perfect procedural packaging. But the moment the envelope was slid beneath the cabin door, it became evidence. And the Attorney General didn't just read it. She documented the delivery timestamp as part of a pattern of retaliatory conduct. Exactly as expected, she said. They're not correcting. They're doubling down. The homeowner knew the rhythm by now. HOA boards don't panic forward. They panic sideways, looking for a loophole wide enough to feel like control again. They think they're safe because it's on paper, he said. They think they're safe, the AG replied, because they believe oversight is optional. They still assume this is a dispute. It isn't. It's an audit they haven't realized they triggered. Retaliation is the doorway oversight waits for. By escalating on record, the board had just opened it. The Attorney General drafted her own notice. Concise, official, and devastating in its simplicity. It informed the HOA that they were now under review for jurisdictional overreach, unauthorized entry, and misuse of regulatory authority. But she didn't send it yet. She waited. Because timing is leverage, and leverage is most effective when the other side believes they still have the upper hand. The inspector returned the following afternoon, but she didn't approach the cabin this time. She stayed parked across the gravel drive, phone in hand, pretending to be conducting visual survey assessment. She wasn't surveying anything. She was waiting for backup, for instruction, for some sign that she wasn't the only one carrying the fallout. The homeowner watched from the window. "She's nervous," he said. "She's not nervous," the Attorney General answered. "She's realizing she's the most visible liability in the room. They're hoping she survives the blow, long enough for them to blame her for it." That was the thing about HOA hierarchies. Loyalty lasts only as long as liability doesn't. They had already started positioning her as the sacrificial compliance officer. The Attorney General finally closed the folder and stood. "They're betting on intimidation. We'll give them documentation instead." She walked outside. Calm, not confrontational, simply present in a way that changed the physics of the situation. The inspector looked up, startled, halfway out of her car, but rooted on instinct. The Attorney General didn't raise her voice. "All communication with this property now passes through my office," she said. "You will not approach the homeowner again. Not directly, not indirectly, not physically, not through notices, not through fines. You are to suspend all enforcement activity until your board receives state correspondence." It wasn't a request. It was the moment. Retaliation ended, and oversight officially began. The inspector didn't argue. She only nodded, eyes lowered. She now understood what the board still didn't. This wasn't a fight anymore. This was a record. She got back into the car and left without another attempt to posture. Inside the cabin, the Attorney General returned to the table, opened the state notice she had prepared but not yet filed. And this time, she signed it. "You're not up against an association anymore," she said. "You're up against their governance model. And once the investigation begins, they don't get to dictate the pace of it. Retaliation had been their mistake. Documentation would be their undoing." Part 3 wasn't the end of conflict. It was the moment the HOA stopped believing it was the one in control, because from here forward, the state wasn't watching them. The state was investigating them.